All right, let's explore the levels of law specifically in the Canadian legal system. So, this is a very old picture, but this is the one that definitely sums it all up. We have lots of different types of law. There's lots of terminology when you're studying law, but this really is a leveled, it is intentionally drawn this way because it shows you really specifically two important pieces of information. The first being the power that a law has in Canada. So, this is intentionally in a hierarchy. So, the laws at the top have more power than the laws at the bottom. And when we say more power, we mean that if the laws were to conflict with each other, the courts would follow the one that is at the top. It is shaped like a triangle because the number of laws in that top category is far fewer than the number of laws in the bottom category. So let's dive in and look more specifically. At the very top of our triangle, we have constitutional law. Our constitutional laws come from our Constitution itself. You've probably heard of it, okay? They are at the top of the pyramid, and so they are going to override all other laws. If there is something written in the Constitution, it must be followed. And if it conflicts with another law that we have here in Canada, then the one that is in the Constitution is going to win. And you might wonder how we might have laws that conflict. Well, you have to remember that in Canada, we only got our Constitution 40 some odd years ago. Okay, before that, it was still controlled by the UK. And so when that Constitution came into power, there was a number of things that were added to it, including our Charter of Rights and Freedoms, which is very progressive compared to a lot of other constitutions in the world, simply because it was written so much later in time. And we're going to dive deeper into that in our next unit. But that means that when things were added to the Constitution, when it was finally written down and given to us in our independence 40 some odd years ago, there might have been other laws that already existed in the lower levels that conflicted with it, that didn't follow it. And so slowly the courts are adjusting those as they are running into these situations where there are conflicts. Okay. As I said, all laws must be consistent with what the Constitution says. They are not yet because they are slowly being dealt with throughout the court system as cases come forward with them. Okay, the main thing in our Constitution is that the Constitution mostly just sets out the power division between the different types of government. We have two main types of government in Canada. We have our federal, which is all of Canada, and then we have our provincial, which is also the same as territorial, which is the government for each of those individual provinces or territories. And they each get to do different things. And because they don't often agree, it's really important that they kind of stay in their lane about what they make laws about. Okay, the other really important thing in the Constitution is that Charter of Rights and Freedom. All right. So for some examples in Canada, our federal government, it has lots of powers, but kind of the most important that we know about, they get to make all of the laws around national defense. That would make sense. That needs to be the same across Canada. They make all the laws around foreign affairs and how we interact with other countries. Again, should be consistent. They handle our currency and our money. They handle our fisheries and oceans. They handle citizenship and immigration, and they handle our criminal laws. All right. So in Canada, our criminal law, how it's carried out, what's included, and what the punishments are consistent across the country. And that is simply because our Constitution tells us that the federal government gets to handle criminal laws. So if any province or territorial government tried to go in and say, oh no, in our province, we want to have the death penalty, for example, the federal government would get to say, hey, now the Constitution says we get to make that decision. We've made that decision across Canada that we don't have the death penalty. And so that doesn't get to stand. You need to, in essence, stay in your lane. And in case you're curious, all of these things are funded between the two main taxes that we have in Canada. The first one being the federal tax that is taken on every dollar that you earn when you are in the country and you are working. And the second is on the federal portion of the tax that gets taken every time you buy something in our country. All right, our provinces are the second category that's divided out in the Constitution. The main ones that we see in the headlines are going to be our education, are going to be our health care. Okay, yes, these are provincial and when it comes to the Constitution, wherever it says provincial, assume that would also mean territory. We have 3 territories in Canada, but they function the same as a province. Okay, so yes, each province has its own educational system in Canada. It's different across the country, and that is allowed through the Constitution. So any action that the federal government might take to mandate something being done in schools in Canada wouldn't be allowed because the Constitution says that that's provincial. Similarly with healthcare, also our natural resources are handled province by province, as well as transportation and highways. And again, this is going to be funded the same way through that money that's taken when you earn income and through that money that you pay when you buy something. It's a provincial portion of it. In some areas, Ontario specific, we do actually have smaller governments that we call municipal governments. Okay, these are not mentioned in the Constitution. So any area that you might be in, like Toronto, that has a municipal elected government, they get their power from the province. So the province at any point could take that power back and say, nope, we're just going to make that provincial again. But it would be specific things for those areas. So water and sewage, libraries, parks and recreation. All right, so that's what comes out of our Constitution. It's really that division of power and that Charter of Rights and Freedoms. The next step down on our triangle, that middle category there, is what we call statute laws. And I want you to think of statute laws as basically any law that has been formally written down and passed by government. Okay, it doesn't matter if it's federal government or provincial government. That was set out by the top ones, but anytime that laws have been passed, that they have been formally written down, that they are available to the public, and that they must be followed, they are going to be considered a statute law. There are very specific processes for how laws are passed and changed in our country. That's for a different lesson. They would be considered a statute law. Okay, again, passed by elected government representatives, either in our parliament, that is in Canada-wide, or the provincial legislature, that is in the province or territory. Okay, you're going to know something is the statute law because, like I said, it's written down, but it's not in the Constitution because that's above us. Okay, and generally it's going to have the words act. It's going to have code. It's going to have bylaw. It's going to be something that, yes, is written down. In the day of technology, we find a lot of it online, but it literally used to be in like books that would be sitting around. Okay, so we have a whole act on tobacco specifically. We have education acts in each province or territory. Okay, we might have bylaws that say you can or can't park at night, or you can and can't have a campfire. Those would be written down things that exist. Okay, we have the Criminal Code of Canada. That is a statute law that is written down. And again, if we are referencing it, if somebody is talking about a law existing, you are going to literally see the name of that. And then you're going to see some information like page numbers or areas or acts or different citations within it. So you can see here, for example, Criminal Code of Canada. That is the written down document. And then there's lots of numbers to help you find your way within it. Okay. At the very bottom of our triangle, which has the least amount of power in Canada, is what we call common law. You'll also have heard this very often referred to as case law. Those two words are fairly interchangeable. Common law is the original terminology that came over from the UK, and this is very common in any countries that were part of the Commonwealth. Some areas like the United States have changed that terminology to case law, but it means the same thing. Okay, these are laws that exist simply because a judge or justice has made a decision. Okay, so the first time that a judge or a justice is presented with this unique scenario that we are in, and there isn't previous decisions for them to look at, whatever decision they make is going to become the standard that all future judges or justices are going to have to look at when making decisions in a similar case. Okay, and so these have become kind of formally known laws that exist. So, for example, in Ontario, we know that public buildings have to be accessible in the sense of physical accessibility. They need to have ramps and they need to have elevators. And believe it or not, this is not a statute law, and it's definitely not in the Constitution. Okay. This is not formally written down. No government passed this. Okay, what happened is that an individual who was in a wheelchair tried to attend an event at a theater, and the only seats that were available to them were, really inconvenient and not great. And they sued the theater to say that they are not providing what is needed for them to attend. And the judge decided in their favor and made the theater spend a certain amount of money to update the theater. Okay, there's obviously all sorts of variations included in there on what that amount of money is allowed to be, et cetera, et cetera. But that was the decision of one judge in one case. And all of a sudden, after that one case happened, we saw all of these other public buildings having accessible things put in. Why? Because now that that decision has been made in that distinguishing case, it means that anytime somebody with a physical disability wasn't able to access a public place, they would be able to very easily sue them and would have this precedent, it's called precedent, this previous case to point to, their lawyers would point to and say, this judge said this in this case, so in order for our legal system to be just, justice should be served. If we think back to those previous lessons, we need to say like cases treated like cases. And so it set this, what we now call precedent, that all future cases are going to be like this. So out of that knowledge that this is the precedent and that at any time we could be sued if we don't accommodate this, we now see public buildings becoming physically accessible because they know what could happen. And this is exactly what we call common law. Okay, when we look at citations of this, we are literally going to see citations from court cases. Okay, and so criminal court cases are always going to have an R in it. That dates back to the UK. The R represents the crown. Literal crown in the UK and now represents the government, okay, because in criminal cases it's the government versus an individual, and then there's the date, and then there's some other information there. Okay, if it's a civil law case, that's two people or two organizations or a person or organization suing each other, then it's going to have the two people with that V in the middle, and again the year and where we can find it. We know that all court cases are all documented and are publicly available to people, and so this is the work of why we really need lawyers, because they're going to be the ones that know better about common law, because as everyday individuals, we just can't keep track of it, right? We can't look through every previous case to find out what decisions have been made on this previously and what things would now be considered law. So this is our triangle, and it very much is the level of laws in Canada because, as I said, the higher up, the more power it has. So when the Constitution came into play, if a law that had been a statute law before, okay, violated that position of power of which government has power or violated the Charter of Rights and Freedoms, then it no longer got to be a statute law. Okay, if there is a common law decision that has been around forever, okay, and then all of a sudden a statute law is written around it. So for example, if our provincial or federal government were to write a formal law about accessibility in certain areas and what is or isn't required, then once that law was passed in government, it would override those common law decisions that we had before. But if there isn't that statute law, then the common law will prevail. And again, it's in that triangle because at the bottom, there's a lot more of them. All of those court cases that we need the lawyers to look through, whereas our statute laws, there's lots of documents, but they are accessible. And then our constitutional law is one document. See you in the next one.